of the State Government Policy, Finance, and Elections Committee. Thank you, everybody, for joining us today. We have a very interesting agenda in front of us today. And so we took the opportunity, by the way, since we're having the hearing, an informational hearing only, no action, but it's informational. And I appreciate everybody who took time today to make themselves available for the hearing today. But we are also added on to the end is an update on the Pharmacy Benefit Manager, the reverse auction implementation. That's a new thing for the state of Minnesota. So looking forward to hearing an update on that as well. So with that, and as an introduction, I just want to mention that residency is an important issue, and it's very straightforward when you do this. However, as it's become aware of the last little while, and especially with redistricting coming up, they're always, every 10 years, if you look back onto the court cases on residency, they're usually in an election year where you have redistricting, and that's coming up next year. And so floods of questions. What does it take to be a resident for the purpose of being a candidate in filing for office? And in a legislative year where you have redistricting, that is more complicated than ever. Not so much that it's complicated, but for the individual who has lines who have changed or the boundaries have changed. One case in point was in my own area in Big Lake Township. The line happened to go through the house of an incumbent state representative. And so the question was, well, what district? And they were totally different districts. It was an A side and the B side. So they made the question to the court, and it says, well, where do you sleep in this house? They said, I have bedrooms on both sides of my house. And basically it's they said to him, pick one. But whichever bedroom you claim, that is the house district that you will file for office in. And so we actually had the choice of which district to be in just by virtue of which bedroom he chose to sleep in. So we may think sometimes that these issues, especially if it's been straightforward for yourself, but pay attention to some of these things we're looking for. But the goal in having this hearing is to have an understanding of what that residency is, and also when we file for an affidavit of candidacy, and some of the issues that are resident there. So we're going to start off today with hearing from the Secretary of State's office. Welcome, Mr. Maeda. Glad to have you here today. And Mr. Maeda and I have worked together on the electronic poll books, on that legislation. Went through many things like that. And we appreciate your long history, Mr. Maeda, being involved in elections. And now you're with the Secretary of State office. So with that, Mr. Maeda, would you first explain your role in the Secretary of State's office? And then I think we gave you some questions to help kind of get things rolling as far as the Secretary of State's involvement in affidavit of candidacy and residency issues. And with that, I'll hand it over to you, Mr. Maeda.
Thank you, Madam Chair. And it is always good to see you because we do have a long history of working together on election issues. So my name is David Maeda. I'm the Director of Elections for the Secretary of State. Prior to becoming the director, I was the city clerk for Minnetonka, and I was also the Hennepin County election supervisor for a period of time. So I've spent most of my career in elections, but I'm currently the director for the Secretary. And
Thank you very much, Mr. Maeda.
I'm not sure I saw the questions. What I thought I would do is we put together an FAQ that we sent to Mr. Bjorn, and I can do a high-level walkthrough of the FAQ on candidate filing, and it certainly answer any questions committee members have. I should also mention I do have to leave at 10:30, and I apologize. I did have a prior commitment. Ms. Strother, our Deputy Secretary of State and Chief of Staff, is here not to testify, but just make sure we're here to the end of the hearing to answer any questions people might have. But I do have to leave at 10:30. So the first thing
Mr. Maeda, that is correct. I just want to correct. We did not give you a list of questions. It was, as you said, to go over affidavit of candidacy, what that takes, what the process is. And then the questions would be from members, if there are any.
Thank you, Madam Chair. So just kind of a high level, the first thing I'll point out is the Secretary of State is one of 1,000 filing officers in the state of Minnesota. School district clerks take the school board filings, city clerks take city council and mayor filings, town clerks take the town board filings, counties take the county offices, and some legislative filings as well. So we are one of 1,000 filing officers in the state of Minnesota, and we all follow the exact same procedure. The affidavit of candidacy is the same form that everybody uses to accept filings from candidates. I've been in elections, as I mentioned, most of my career, but my first election was 1996, and the form is substantially the same as the form we used in 1996. There was a change in the law in 2010 that I'll kind of walk through. I actually, Madam Chair, watched last night the House floor debate on that change in 2010, and you spoke in support of the bill and raised some good questions about it. But so I just wanted to get some more background on why it changed in 2010, because I didn't remember the change, quite honestly. So again, we are one of many filing officers in the state of Minnesota. To file for office, all you know that have run for office, obviously, you have to file an affidavit of candidacy with the filing officer, and that includes a filing fee that varies depending on the office you're filing for, or you can submit a petition with signatures to go along with your affidavit. That tends to be done more at the local level than at the state level. So again, you file an affidavit of candidacy. The big things, and I'll get into what changed in 2010. The big change in 2010, prior to 2010, you didn't have to give a residential address. You could list a PO box as your address. And the push behind that legislation was to make sure that that there was some information available that the candidate actually lived in the district. But and it's 204B06 if you want to look at the actual statute. But there are really three parts. So your residential address became part of the record. There was the option, which has been somewhat in the news recently, of there is a process for people that have some type of protective order to make the residential address private data. They still have to give the address to the filing officer, but it doesn't become public data for safety purposes. And the third part of the law change in 2010, and it's actually, I just lost my thought. There is a third part of the change that kind of goes along with the other two. It'll come back to me. I'll keep going here. So again, there are mandatory things every affidavit has to contain. It has to contain your name, and you can use your name you're commonly known in the communities. Thus, Jesse Ventura was able to file for governor as Jesse Ventura and not James Janos. You can't add something to your name that gives you an advantage like MD or CPA or some title. So there are some restrictions, but you can file as a name that you're most commonly known in your community. Again, there's a filing fee. Another big change in 2010 was it was mandatory to collect the phone number. And again, this was obviously meant so that we could contact the candidate if we needed to. And I remember the third part, which was probably the most important part of 2010 change, is that there is a process for any registered voter in the state to question a candidate's address in the district. They have to do so in writing, and then the filing officer verifies whether or not that address is actually in the district. And if it's determined it's not, then there's a process to not accept that affidavit. But if it's if the address listed on the affidavit is actually in the district, the filing officer has no discretion. They have to accept the affidavit. There's been a question, the more common way to question somebody's eligibility, specifically residents in the district, is to use the errors and omission statute 204B.44, which is actually a court process. You go to the court, and the court makes the determination whether or not the person is an eligible candidate in that district. And that's the more commonly used method. I've never heard of the method of registered voter questioning. I'm sure it's been used somewhere in the state. It's, in my experience, I have never come across that. The last thing I'll point out to your comments, Madam Chair, about the determination of residence is actually the same one that we use for all elections. So determining a voter's eligibility to for the registration status, Madam Chair, you actually touched on the one we usually use to explain to voters how to determine their residence. And again, this is in 200.031, but it's subdivision 8, and it's the one that says it's where you sleep most nights. But there are 13 provisions of that statute. It's basically where you live and you have no present intention of leaving that residence is one of the primary determinations. I'll add another anecdote to yours, Madam Chair. In 2010, there was when the city of Edina got redistricted, there's a legislative line that went down cut an apartment complex in half. So half of the residents were in one legislative district, the other half were in the other. So there are things, to your point, redistricting does sometimes cause issues on where the exact line gets drawn, but the determination of residence is in the election statute as far as not only voter registration, but for candidates as well. And with that, Madam Chair, I think that's all I will say in my comments. I'm certainly happy to answer any questions.
Okay, members, questions, and I see two. Senator Pratt, would you like to go first? And then I'll call on Senator Howe. You're muted.
I didn't have my hand up, Madam Chair, but
I'd
be
happy.
it's
my little white hand that floats, and when it's a cursor. All right.
But Madam Chair, I guess I will ask one question, and that is, Mr. Maeda, you talked about the affidavits and the voter challenging. I guess what I'm wondering is who has enforcement for the rules that have been put in the statute in 2010, right? For any verification, or if through common knowledge, there is some question about residency, who takes the lead on enforcing or investigating?
Mr. Maeda.
Madam Chair and Senator Pratt, it's basically two different processes to determine if the candidate is eligible to be placed on the ballot. That typically, as I mentioned, gets determined by a court using the errors and omissions statute. If it's determined that this is a legal document with an affidavit has a sworn oath on it. So if it's determined that the candidate lied on the affidavit, then that would involve like the county attorney investigating.
Okay, Senator Pratt. All right. Senator Howe, and then I'll go to Senator Carlson. Senator Howe.
Thank you, Madam Chair. And I guess in my district, we have some colleges, and how do they, when you look at number 8, and I see that you usually, when you mention that's usually where they sleep and live, but how does that work with when you got an individual that lives in a dorm and that 9 months later they're going to leave and not live in the dorm because you can't live in a dorm normally year round? How does that work with a college student that normally has a permanent address on file with the college, but yet they're voting in the precinct where they're going to school at? How does that work?
Mr. Maeda.
Madam Chair and Senator Howe, that's a great question. You have to kind of look at the entirety of 200.031. One of the provisions, as I mentioned in my previous comments, was you have no present intent on moving. So it's really, I don't want to get into specifics because every student, I mean, when I went to college, I lived in the dorms, but I continued to use my parents' address as my home address because every summer, to your point, I would move home. And so I didn't look at the statute back then, but I considered my parents' home my permanent home, and I was at school living in a dorm temporarily.
So, a follow-up, Madam Chair.
Senator Howe.
So when we look at that, how do they file for office with that affidavit? And I guess that would go back to a legal challenge again, because there's no verification of that, correct?
Mr. Maeda.
Madam Chair, or Senator Howe, sorry. I'm not sure I entirely understand your question, but no, as far as verification, we take the address that's on the affidavit. There's no determination that that person, say in your previous scenario, a student running for something lists their dorm address. The filing officer would take that as their residence. There's no verification to check if they're indeed going to go back to their parents' home. That would be, again, if that issue came up, it likely would be taken, somebody could challenge that in the court.
All right, thank you.
Thank you, Senator Howe and Mr. Maeda. Senator Carlson.
Yes, thank you, Madam Chair. Mr. Maeda, I had a question about when you talked about the 1,000 officers that take the registrations or the affidavits for office. If there's a complaint, how clear is it just where that complaint is delivered to? For instance, are complaints about a city office only given to the city, county, so on like that? So are there specific, is there any specific law that tells you where that complaint should go? What level the complaint should be made to?
Mr. Maeda.
Madam Chair, Senator Carlson, it really depends on what type of complaint. If it's a complaint about the eligibility due to residence, that indeed would go to the filing officer, because the filing officer is the one that accepted the affidavit.
Senator Carlson, do you have a follow-up for that?
I think that answers. So in all cases, it would go to that filing officer. It wouldn't go to, for instance, for the city, a complaint about the city, a candidate, it wouldn't go to the county or to the Secretary of State.
Mr. Maeda.
Yeah, Madam Chair, Senator Carlson, that is correct. We might hear about it at the Secretary of State's office, but we don't have any authority since we're not the filing officer in that case. I
guess I do have one additional thought.
Senator Carlson.
Yes, thank you, Madam Chair. Mr. Maeda, would there be an investigation by that filing officer, or would that filing officer look into probable cause of some, I don't know if we're talking perjury if the person has given an incorrect address or a false address. Would that be turned over to law enforcement at the local level? And I'm just wondering, what's the process of, and I think this is kind of like Senator Pratt's question, who has responsibility to follow up on this? And is there if there is probable cause for some violation of law, who is that directed to?
Mr. Maeda, if you can help with that.
Yeah, Madam Chair and Senator Carlson, again, kind of to my response to Senator Pratt, the statutory process, if a registered voter challenges the residency of a candidate, basically the statute lays out the filing officer verifies whether or not that address is actually in the district. And that's the only discretion the filing officer has. If it's in the district, we're required to take the affidavit. If it's not, then we can't put the candidate's name on the ballot. As far as if there's further violations, again, any violation of election law typically goes to the county attorney.
Okay.
Madam Chair, one additional.
Yes, Senator Carlson.
In the case of a person filing a committee, now this would be Campaign Finance Board question. Is that something that the complaint would be outside of the filing officer? Because it would be beforehand. It would be something that would have to be, the complaint would have to be filed ahead of time, ahead of filing for office and getting on the ballot. So if the committee address is incorrect, then that complaint would probably go to the Campaign Finance Board. Am I correct on that?
Mr. Maeda.
Madam Chair and Senator Carlson, I'll let my counterparts from the Campaign Finance. Yes. But there is a process for any campaign related complaint. The Office of Administrative Hearings can conduct a hearing on it. There is a process for campaign specific complaints.
Mm-hmm. Two very different tracks. Thank you, Mr. Maeda. Thank you, Senator Carlson. Mr. Maeda, I have a question for you. What would it take? You mentioned just now that when you're a filing officer and a candidate files the affidavit, that you verify that that address put on that affidavit of candidacy is in the district. Is that what you do? Do you actually verify when the address is put on the affidavit of candidacy? Is that what you do in the Secretary of State office?
Madam Chair, we do not verify every address that's given to us. If the candidate obviously has a question about what district they live in, we'll help them by pointing on a map or looking at the precinct finder. In Minnetonka,
Okay.
if the address is clearly not in the district, say that the legislative district is in the Twin Cities and the candidate lists a St. Cloud address, obviously we would raise it at that point if it's clearly not in the district.
Thank you very much, Mr. Maeda. I know that's been a big discussion amongst filing officers in the past. What is their job to do as a filing officer? And generally, the responsibility has been on the candidate. If an officer is helpful, but it's not required, would that be your sense also, Mr. Maeda?
Madam Chair, yes.
Okay. Mr. Maeda, let me ask you another question, though. It says here in the statute 24B.06, the candidate has to certify on this affidavit that a police report has been submitted or an order for protection. So first of all, is there, when a candidate checks that box saying they have that form, either an order for protection or a police report, does the Secretary of State office have an actual form to do that? Or is it just up to the candidate to put the information somehow on a piece of paper and include it with their affidavit of candidacy? Mr. Maeda.
Madam Chair, we do have a form, the standard form.
Okay. Standard form that they would use, okay? They certify. Is there a perjury statute cited on that form or in the statute 204B.06? Or is it just a self-certification?
Madam Chair, I will have to get back to you on that. I will mention they do still sign the affidavit itself, which has that attestation to it. I'm not sure that the other form actually does. I'll have to get back to you.
Okay. And then the question I have for you also, there's one day after filing closes where a person can make a request to the filing officer to check on that address. Can you recall if you have had that request within that one day?
Madam Chair, I have never had that request during my entire career.
Okay. And then the question I have for you, Mr. Maeda, in regards to verifying that that alternate address, this is the one where they check the box and do not put it for public view under the affidavit of candidacy. So they use the form that the Secretary of State has. And does the Secretary of State office then check that address on that form in any way for any purpose, Mr. Maeda?
Madam Chair, no, we do not.
Can you address that issue as far as the Secretary of State office possibly in a future legislation being required to do so or being required to verify residency? Could you address that matter about what that would mean to the Secretary of State office?
Sure, Madam Chair. I think in 2020, there were less than 15 candidates that used that particular provision. So it would not be overly burdensome for our office to check that private data if the address is actually in the district. We would need, of course, you and the legislature to tell us what to do if it's not. I mean, clearly we couldn't take the affidavit, but the process that we would use to reject an affidavit currently isn't in statute. And I will point out, again, it wouldn't just affect our office. Any candidate throughout the state could use that form to keep their address private. So it would affect every level of government.
So, Mr. Maeda, when you're saying 15, is that statewide from all filing officers or just the Secretary of State office?
Madam Chair, is just our office.
Okay, so considering how many filing officers there are, there could be others. Another question I have for you, Mr. Maeda. So when the candidate checks the box and certifies that a police report order for protection, is that attached to that alternate form after they've checked the box? Does that police report or the order for protection, is that attached to and included with the use of that checkbox?
Madam Chair, no, it's not. Although I'll point out there was one candidate in 2020 that I talked to that wanted to keep their data private. And I pointed to the statute that required either a police protection or a court protection order. He did not have that, so he could not use that form. So we do point out that when a candidate.
Oh, you just muted yourself, Mr. Maeda, sorry.
How did I do that?
Cursors, floating cursors.
So no, we do not actually get a copy of the order.
Okay, that's helpful to know that. And we do have Mr. Triplett here from the county, which we will go to as well to get some additional information, and we may do that. I see that Senator Howe has a question.
Thank you, Madam Chair. And Mr. Maeda, in your experience, you've got a long breadth of experience in elections. Is there anything that you can see with the determination of residence or affidavit of candidacy that you would think of that we possibly should alter or change or improve on?
Mr. Maeda.
Madam Chair and Senator Howe, nothing really. I would caution against giving filing officers too much discretion. We don't want 1,000 different opinions on what we can take. It has to be very black and white, I would say. And I think the current statute pretty much is that. And that would be my own. Nothing comes to mind immediately. Obviously, each one of our processes can probably be improved. And Madam Chair, you and I have worked on that over the years on a breadth of election issues. But for this particular one, I can't think of anything I would suggest needs to be changed.
Thank you, Mr. Maeda. Thank you for the question, Senator Howe. I would say for us as legislators, I think the big thing of filing officers, as Mr. Maeda and Mr. Triplett would recognize, they're to really stay out of the some of those things that they're there for the filing, the person who files, whether it's a business filing, UCC, other things. If they ask for help, ask for questions, we certainly answer them. But in general, the goal is that we take the filing. Otherwise, you end up being in a situation of being somebody's attorney, and we are not in that position, or giving advice and other things. And it can get a filing officer in some issues come up then. And I know many times the intention is to be helpful, but I know that in the training it is very important to be careful with that. So I would say at this time, Mr. Maeda, I think that if we are going to do it or going to reduce some things, make it specific and clear so that the filing officer has that clear direction. I hear you in regards to that. Most importantly, if we as legislators decide to make some changes here. I don't see any other questions right now for you, Mr. Maeda, and concerning your time, respecting that, appreciate that. So I've got about 10:32, and so I think if we have other questions, we certainly know where to reach you. We appreciate your availability. Thank you, Mr. Maeda.
Thank you, Madam Chair and members.
Members, I know we do have Julie Strother on right now. I don't know availability for other things. And Ms. Strother, do you want to address Mr. Maeda? We kind of put him on the spot with asking about any questions and stuff. But I think for you in your position, if you just introduce yourself and maybe address any of these issues and the questions that you probably heard.
Madam Chair, Julie Strother, Deputy Secretary of State with the Secretary of State's office. I'm mostly here to answer any additional questions. I think our elections director covered the breadth of the questions. And I know Mr. Triplett is on as well, who can probably answer questions from the perspective of a filing officer at the local level too. So I'm here to answer any questions as needed. Mostly backfilling because Mr. Maeda had to leave at 10:30. So thank you.
Yeah, thank you very much, Ms. Struther. I appreciate your time and availability. And actually, members, I think it's just so appropriate at this time. Mr. Triplett, if you don't mind, the topic is right here. And I think it's always really hard when we move away from the topic and then you have to come back in and do that again. If you wouldn't mind, maybe you could address comment from a county point of view in regards to all the discussion you currently heard with the Secretary of State office. Mr. Triplett.
Madam Chair, members of the committee, thank you for having me. David Triplett, Ramsey County Elections Manager. From what David Maeda provided, we all use the same form across the state, all filing officers. And our process is pretty straightforward, as David said. Our general job, Madam Chair, is to ensure that there's proper completion of this document before we accept it. Obviously, that means everything has to be completed properly. And then we also point out all the affirmations that they're signing to. Various offices have certain regulations. Most of them are the same, but we want to point those out. And we always do that before they're signed. Once we have a signed document and it's properly completed, one copy goes to the Secretary of State's office, one goes to the Campaign Finance Board, the other we then publish. And then, as you're well aware of, Madam Chair, we use the other copy to create the ballots office. So we have the exact name, title, office that the candidates are seeking. And then that's really kind of the end of our process with the filing of an affidavit for candidacy. So I really have nothing more further to provide than Dave Maeda, but if you have any specific questions as a local filing officer, I'm very much ready to take those.
Thank you, Mr. Triplett and members, and if you have questions. And so, Mr. Triplett, when I talked to Mr. Maeda, so in Ramsey County, using the checkbox on the police report or order for protection, about how many did you have, and if any, in 2020?
With no data in front of me, but being the filing officer, I'm aware of 0. Similar to David Maeda's experience, we do have a lot of people that ask about it. And then when we point it out and that you have to have this police report, a police report has been submitted, they generally then move on from that one. So without the data in front of me, I believe it's 0. I can confirm that when I leave here. And if it differs, I'll send a note to Alex and she can spread that out to the group.
Sure. And another question is, there's this one day where a filing officer can be asked to review. I just want to get it to it. It's on the statute here, 204B.06.
Recording in progress.
At any time up to 1 day after the last day for filing for office, if requested, the filing officer must determine whether the address provided in the affidavit of candidacy is within the area represented by the office the candidate is seeking. Have you ever had that request in that 1 day?
Madam Chair, in my 2.5 years experience as the manager in Ramsey County, I have never had one of those requests submitted to my office.
Okay. I appreciate the qualifier, 2.5 years. That gives you, but even Mr. Maeda in his length of time did not. And the other question I have for you is, so Mr. Maeda, and I know that if he answered this, that including the order for protection or the police report is not required by statute currently to be included with that on the affidavit with that alternate form. So I would suppose that you locally as well do not collect the police report or the order for protection. Would that be correct, Mr. Triplett?
Madam Chair, that is correct. And if I discover differently from my staff, I will let the committee know. But again, in my experience, that is the correct.
Right. So I appreciate that, Mr. Triplett. You've always been very responsive and very helpful to us in answering our questions. And it is the best source that we have is to go to the counties. I want to mention also, members, we do have 87 counties. We did invite Debbie Erickson, who is the Association of Minnesota County. I'm not sure if it's the officers. But anyway, Debbie is usually the one that has a lot of experience with all of the counties, but she was not able to be with us today. And we appreciate Mr. Triplett coming in, but we understand that you're addressing what you know about Ramsey County and not necessarily the other 86 counties. And so I just wanted members to understand that. Senator Howe, you have a question?
Thank you, Madam Chair. And Mr. Triplett, how soon if a candidate files at the Secretary of State's office instead of your office, how soon after that filing do you find out about the filing? How much of a delay is that? I'm just concerned that, would it be better to have them all file in the county where they're filing, or does it make sense to have them file at the Secretary of State office? I just wondered if there's a big delay or if it's relatively quick.
Mr. Triplett.
Madam Chair, Senator Howe, it's as quickly as your staff can enter this form into the state database. So in my office, I expect my staff to enter these forms within 24 hours of filing or the end of the day. Generally, we do the end of the day. As some of your candidates, we get a lot of calls from candidates who go home and refresh to see their name on that database. So in my office, I expect my staff 24 hours. Generally, though, it's the end of the workday. Dave Maeda or Julie Struthers could speak more specifically to the state, but again, it's as quick as you can get this document typed into the statewide voter registration system. Then it becomes public, then it is shared amongst all the local election officials across the state.
Thank you, Mr. Triplett. I would say the hardest thing is the last day of filing. And I would suspect Mr. Triplett and some others as well, there are those who would stand outside the offices. And because even though that is a pretty quick data entry, nonetheless, on the last day of filing, it's a hot commodity as far as being in the county offices or the Secretary of State office. And that's normal and customary. And people are interested in whether the situation is there. A question for you also, Mr. Triplett. The question has come up as far as taking the time to verify each address being required as a filing officer, or in particular, when they check the box so it's not publicly visible for others to check, the time it might take to have to do that. Could you address that, Mr. Triplett?
Yeah, Madam Chair, if it's just verifying that the address on the affidavit is within the district, that would not pose much of a burden on my staff. I have the entire filing packet you receive here. There's a lot of stuff we go over. So to put an address in Google or whatever the means to verify it would be, I don't see would be an additional burden because we already have to go through quite a few documents when somebody files beyond just the affidavit.
Okay. And members, there have been conversations sometimes about, just how far, what kind of time would it take for the Secretary of State to do this? And if you take a look at this determination of residency 200.031, as you can see, it's rather extensive. And so from what I've heard so far from the Secretary of State office, I don't know that they're interested in taking on or other filing officers and going through 200.031 and going through all of that. Would that be the case, Mr. Triplett, for you as well?
Madam Chair, I'd have to review the residency requires in that statute. I've seen it. It's fairly thorough. To verify that, I'd have to do a little more research to see what the burden would. But as always, our job is to carry out the law as passed. So we will do whatever the law says we have to do.
Thank you, Mr. Triplett. Excellent answer. So members, with that, I think we've covered some of that. The one thing I do want to do is we have an opportunity now. Normally, we would start with having Ms. Stengel, our general counsel, go through what the statutes are to just refresh our memories and get that all up and up. But because Mr. Maeda could only be with us a half an hour, we went ahead and took him first and did that. And now we're going to go to Ms. Stengel, who's going to walk through some of the things. The next item will be we'll go to the Department of Revenue campaign finance. So one of the things is to realize the various pieces of residency is something of matter of interest. So with that, Ms. Stengel, if you would go ahead and go through some of the residency statutes that have been sent out, as I understand it, Mr. Bjorn, that this has been sent out to members, and then also Ms. Stengel is doing a screen share for you as well.
That is
go ahead,
correct.
Ms. Stengel. Okay, thank you, Ms. Stengel.
Thank you, Madam Chair and members. I hope you can see the PowerPoint slide. If not, somebody let me know. And there appears to be a weird green line on my screen. I don't know what that's about. So if you see that, I apologize. So I think you all know who I am, but I'm Lexi Stengel. I'm the Senate counsel for the committee. And we're going to sort of do some backtracking to sort of cover some of the basics and fill in maybe a few of the gaps. Get rid of that. Okay. So the very basic concept is that you have to live in your district, and the amount of time you have to live in your district depends on what office you're running for. For example, if you're running for Congress, you don't actually have to live in the state when you file for office, just when you are elected. When you run for a state legislative office, it's 1 year in the state, 6 months in your district. And that sort of, continues to vary throughout the other offices. So to talk a little bit about affidavits of candidacy, we've talked about these a lot, but the basic concept is that this is something used by a major party office, partisan office or nonpartisan offices. So this is a large majority of people that are filing for office fill out this form. This form requires you to say that you do or will meet residency requirements, your phone number, and as we've talked a lot about, it requires you to have your address of residence. And in some cases, you can request that your address be private and instead use your campaign contact address. So in this case, this is what we've been talking about. In that case, you have to fill out the separate form attached to your affidavit, and that includes your address of residence. And that piece of your address is kept private, and everything else on that form is kept public. And again, you have to either certify on that form that there has been a police report, an order for protection, or that your data is somehow otherwise private. And it's important to note, this question comes up quite a bit. These address requirements don't apply to judges that are running, county attorneys, or county sheriffs. They're exempt from these requirements altogether. They don't have to check a box or anything. They're just exempt. So looking at address of residence. So there are a couple of ways you can look at this. There's one aspect is the address you live physically within the district? And then there's the question of, does a person actually live at that residence? And as we've talked about, the courts, when they're looking at, does somebody actually live where they say they live, they'll look at that list of 13 factors. And I won't go through all of them. You have them both in David's handout and the statute, but they sort of break down into what I think of as 4 categories. I think other people break them down differently, but the idea is the location, where you are intending to live, where your family lives, and there are some special provisions for temporary residents. We talked about college students, or if you travel a lot for work or those sorts of things. And there isn't really one of these that rises to the top and says, this is the way to do it. It's sort of a balancing of factors. I think the college kid example is really a good one because it looks at, the location, it looks at intent, it looks at your family, it looks at all these sorts of things. And it's sort of a balancing of factors. So we've talked about the filing officer reviewing addresses, and I want to sort of break that down a little bit more. So we've talked a lot about filing officers and how they vary by who is filing. So just as a quick reminder, all federal offices file with the Secretary of State. State offices can file either with the Secretary of State or the county auditor in the county where they live. County offices file with the county auditor, and then local offices like school districts, city councils, those places file with the city clerk, the school clerk, those sorts of folks. So that's how we end up with having 1,000 filing officers. So the process for reviewing address that we've talked about, this is only for addresses where the residency requirement must be satisfied by the close of the filing period. So if you don't have to live in the district and you file, this process is going to be sort of nonsensical for you. But for example, for legislative offices, you do have to have your residency established before you file. So this would apply to legislative offices. So in this case, a registered voter may make a written request to whatever filing officer received that affidavit of candidacy and ask the filing officer to review that address. And it's important to note that this doesn't look at whether the person actually lives at that address. So they're not looking at that factor. They're not looking at the intent factors. They're not looking at where they sleep. They're not looking at where their family lives. This is really just about, is the address provided physically within the district? So that could be, you know, looking at 101 Main Street, you know, I pull it up on Google Maps. Sure, yep, that's in the district. And it doesn't really go into, does that person actually live in that house? It's just about, is that house in the district? So if the filing officer finds that that address is not within the district, the candidate is notified and their name is not placed on the ballot. And that determination can be appealed through that errors and omissions process that we've talked about a few times. And then just one last thing, nominating petitions are another way to file for office. And this is how a minor or independent candidate files. They do this instead of an affidavit of candidacy. And this sort of has fewer regulations about addresses and what to do with them. So a nominating petition must include their address, including their street and number. But there isn't that same review process that you can ask for from the filing officer. There's no option to keep your address private on these nomination petitions. And then, of course, like the affidavit of candidacy, these are available for public inspection. So the nominating petition is treated a little bit different than the affidavit of candidacy. And that's all I have for you. I'm happy to answer any questions if there's questions about what the law says.
I see Senator Howe has a question. Senator Howe.
Ms. Stengel, why would we have two different processes? Can you explain that to us? As why wouldn't we just have one process, either the affidavit or the petition piece? What's the purpose of each?
Madam Chair and Senator Howe, that's a great question. I think it's really interesting and I don't know the answer to it. I think it has to do, if I were to guess, because you are a minor party candidate or an independent candidate, I think the idea is that you need to show that there's support for you before you're put on the ballot. So you have to have signatures as a petition instead of just filing your own affidavit of candidacy. But I don't actually know that's the case. That's my own guess. I don't know if somebody else here might know why there was that division, but there it is.
So Ms. Stengel, a follow-up from Senator Howe's question is, looking back on the history, there were some 1981, 86, 97, and 99. These are chapter 200.031, which is the determination of residence. So generally, Ms. Stengel, this chapter 200.031 is the residency statute for an affidavit. In other words, those two, when it talks about residency and affidavit of candidacy, the way to determine residency is using the statute 200.031. Is that correct?
I think this is a really, sorry, Madam Chair, I think this is kind of a confusing question. Because determining residence, that's about, does the person actually live in that house? And that's the challenge that you'd have to take to the court. And the court would look at those 13 factors and say, yes, this is what we're finding. When the filing officer is reviewing, they're not actually looking at that. It's my understanding that they're just looking at the physical address.
Thank you, Ms. Stengel. That was the purpose for asking the question. Because I think it's this whole filing officer duty responsibility, what do they do, is a really important consideration for us. Senator Howe, you have another question?
Well, and your question begs this question. So they're just checking the address. So that could be the local county transfer station as far as garbage transfer station. It could be in an industrial park, not truly a residential area, but they're just checking the address to make sure the address is in the precinct. They don't check anything else. And I think that's, I find that interesting.
Yes, it is, Senator Howe. I have another question. When you talk about reviewing, that is, Ms. Stengel, that's based upon that one day after filing. That is when the opportunity to review, that's when they would do that. Is that what you were referring to, Ms. Stengel?
Yes, Madam Chair. So a registered voter can request that review at any time up to one day after the filing. So it could be earlier in the filing period if the candidate filed earlier. And again, that's only triggered if a registered voter makes the written request. There's no sort of automatic review process.
So it must be in writing?
That's correct.
Okay. All right. Senator Pratt, you have a question?
Thank you, Madam Chair. Ms. Stengel, we've heard about this one-day voter challenge. I want to come back to the question I asked before. If it becomes public knowledge that a candidate does not live within the district, are there any other methods to challenge that filing other than a voter putting that forth? And what happens if that challenge comes more than one day after the close of the filing period?
Sure. Thank you, Madam Chair and Senator Pratt. Yes. So it sounds like what you're asking about is not sort of that physical address thing we've been talking about with the filing officer. You're talking about whether the person actually lives in the house. And that would be an errors and omission petition. And that's a separate process. Again, that can be brought by any individual, and they file a petition with the appropriate court. So whether that's the Supreme Court for federal and state offices or a local court. And that process, you file a petition and you say that there is an error, an omission, or a wrongful act that has occurred or is about to occur. And one of the reasons you can file the petition has to do if you're placing or putting the name of a person on the ballot that is not eligible to hold that office. So then what the court will do is take that, they'll look at sort of the totality of the situation. They'll look at those 13 factors about residency. They'll look at intent and where they sleep and all of those other things. And then the court will decide, yes, that person is a resident of the district. They do live in that address, or no, they don't. And if they don't, then the name is either removed from the ballot if it's early enough. And if it's later on in the process, the court can decide if they need to invalidate that election.
And
thank you, Ms. Stengel. Senator Pratt.
Thank you, Madam Chair and Ms. Stengel. So does that have to come from a registered voter within the district, or can that be any, whether it be Secretary of State, county attorney, can anyone begin that errors and omissions process?
Ms. Stengel.
Thank you, Madam Chair and Senator Pratt. I'm looking at the statute now. It's 204B.44 if anybody else wants to follow along. And it starts out by saying any individual may file a petition in the manner provided by this section. So I read that to be, any person. It doesn't appear to say, let me do a word search. Yes, there's nothing in here about you having to be a registered voter of that particular district.
Okay, thank you, Senator Pratt. That was a good question. So, Ms. Stengel, Mr. Bjorn, if you'd go ahead and send out 204B.44. I know you sent out some other things, but obviously this needs to be included with our list. Ms. Stengel, there's another area. I think there's a requirement to live in that district or in that residence for a certain amount of time, and that's connected to residency also. Could you refresh for an affidavit of candidacy or eligibility to be a candidate? What is that residency requirement?
Yes, thank you, Madam Chair. Thank you, Madam Chair. It depends on the office that you're running for. For state representative, state senator, you must live in the state for 1 year and within your district for 6 months. For governor or lieutenant governor, it's 1 year in the state. For judges, it's living in the district at the time of your selection or election. For most local offices, it's living within your district for 30 days. For U.S. representative and U.S. senator, there's no necessarily residency requirement of when you file, but you have to live there when you're elected. So for all of you members on the committee, you know that you've had to live in your office for 6 months, and that's sort of where it ties in with redistricting. After the district lines are drawn, the decision might be necessary. Do you need to move across to run in your old district or not? So that, I think, is sort of a timely question as well.
And Ms. Stengel, thank you very much for that. I think that you're right. That is important consideration. And it's 6 months from when? What is the measuring of 6 months? From the election day or end of the year?
Thank you, Madam. Yep. Thank you, Madam Chair. It's from election day.
Okay. All right. Okay. Any other questions, members? And as you can tell then from what Ms. Stengel has said, I think that helps to clarify. It would have probably been good to have had kind of that basis even prior to the Secretary of State's office, but it was necessary and we're grateful for that. But I think this helps to kind of clarify things quite a bit. And members, if you have further questions, feel free also to contact Ms. Stengel. But generally speaking, if you use the statute, those are there, and the interpretation of that is up to you as well. With that, members, I don't see any other questions. We're going to go ahead and again on this residency issue that contributes to it in Minnesota, the Department of Revenue does a lot of work also with determining residence. I remember back a few years ago, the snowbirds and are you a resident? Was it take to be a resident? And sometimes I just really felt it was important to take advantage of the Department of Revenue. And they have a lot of experience and knowledge with residency as well, even though from a little different perspective. So I felt to just get a full sense of that, we've asked the Department of Revenue. And Mr. Getchell, are you going to be doing the presenting today for Revenue?
Madam Chair and members of the committee, yes, I will be. Thank you for having me this morning.
Well, thank you for being here. We really appreciate your taking the time. And with that, Mr. Getchell, I think you have a presentation as well, members. There is a PowerPoint as well, and he's going to do a screen share. Mr. Getchell, before you start, again, just for the audio record, especially your name and title. Thank you.
Yeah, Madam Chair, members of the committee, good morning, and thank you for having me today. I'm Dan Getchell. I'm the Director of Individual Income Taxes and Withholding Taxes at the Department of Revenue. I've been working at the Department of Revenue for right around 14 years now, most recently the last few years as the Director of Individual Income Taxes and Withholding Taxes. So thank you for having me today.
Glad to have you here, and thank you very much for your time.
Yeah,
Mr. Getchell, you can go right ahead.
Thank you, Madam Chair. So today I'm here to talk about residency and how it relates in terms of tax purposes for individuals themselves. Please let me know if you can't see the PowerPoint. I hope you can. But just to speak at a broader level, the state really provides broader constitutional power to tax residents than non-residents. And so it's really important when we're working with taxpayers that we make the proper determination of whether or not they're a resident versus a non-resident. For residents, they are subject to tax on all of their income, whether it's earned in Minnesota or outside of Minnesota. They are subject to tax on all of their income once it's determined that they're a resident. For non-residents, however, they're only subject to the tax on the income that they earn from Minnesota sources. So that creates a huge difference when it comes to their taxable income. And so it's a really important thing to determine to make the proper determination on whether someone's a resident versus a non-resident for tax purposes. To do this, Minnesota law provides us with two different tests that we can use to determine whether or not an individual is subject to income tax as a resident. The first test is the domicile test. The domicile test is really looking at the individual and where their intent is to be as a permanent resident. And so similar to some previous presentations, it's really looking at that person's intent as a permanent resident. The second test that we have is really the statutory or physical presence test. So this is looking at that resident over a calendar year and taking a look at, that taxpayer over a calendar year and determining, okay, where were they physically located during that calendar year? I'm going to go a little bit deeper into the two different tests. So the first test, the domicile test, it's widely used to determine legal residence, not just for tax purposes, but it's widely used. Once again, it's focusing on the intent. So I think an example that was given earlier was a college student. Well, that's not, their intent isn't to be a permanent resident, potentially where they're going to college, right? Their permanent residency could be where they are, where their parents live, where they are physically located during the summertime, and that could be their intent to be a permanent resident there.
Recording stopped. Recording in progress.
In determining the intent of a taxpayer, we use a series of court decisions as well as the administrative Minnesota rule that I've listed in this slide. And both of these set out all sorts of relevant factors for us to utilize to determine the intent of that taxpayer. To highlight a few of them and actually to kind of group them up into larger groups or larger areas, we put in this slide just the larger groups. You can go to our website and you can see it listed out, or you can go back to that administrative rule and find all of the details right within that rule. But we're looking at things like the employment. Does their employment make it so that the intent is to be a permanent resident of Minnesota? Their home and their living arrangements. Is their home in Minnesota where their family resides? Is it where is it a bigger location that can actually host their whole family versus another location they might have? We're looking at business relationships. We're looking at their family and community connections, social and civic relationships, statements and declarations of legal residence. So any type of document where they are listing Minnesota as their permanent residence. Looking at spousal presumption. So we're taking a look at where their spouse lives, where family members live, where they might work, and utilizing that in our determination of whether or not someone's a resident. Now, with this list of factors, I want to state out that each case is unique. Every taxpayer that we work with has a very unique situation. And when it comes to these factors, they have different weights, and they might have different weights depending on that taxpayer situation. And so when we're looking at all these factors, there's no set number like, oh, one of these factors meets, all of a sudden they are determined to be a resident. It's our job to come up with a solid case that this person is a resident, and we utilize all of these factors in court to support our case that we determine this person to be a resident. And so for one audit versus another audit or another case where we're working with the taxpayer, one of these different factors might have a little bit more bearing than another. If we're unable to determine whether or not someone's domiciled based on those factors, we do have an alternative test in Minnesota law, and that's a statutory residency test. And so these are for taxpayers that are not domiciled in Minnesota. We're going to look and we're going to say, okay, do they meet both of the following conditions? If they meet both of these conditions, they then can be deemed a resident as well for tax purposes. So the first condition is that they must maintain a place of abode within Minnesota. The second is that they must be physically present in Minnesota for more than half the tax year. We refer to this as the 183-day rule. It is the taxpayer's responsibility to substantiate where they are located within that calendar year to prove otherwise if they feel they are not a resident of Minnesota. And we do several different things to gather this information and to make these determinations of our taxpayers. We'll meet with the taxpayer. We'll have discussions regarding where they were physically located, where they weren't. We'll have discussions around all of the different factors. We'll also look at all sorts of facts that are provided to us through the audit process. We might be looking at bank statements, other financial records, but we are looking at all sorts of facts, and those weigh a little bit more than the conversations that we're having with taxpayers. As always, facts are a lot more presentable in court. And so we use all these things to determine whether or not a taxpayer is a resident of Minnesota. And with that said, I really just want to end with there is an extreme importance to determine the residency of the taxpayer. There's a large difference in their obligation to the state of Minnesota, whether or not they're deemed a resident versus not a resident. It really determines their taxable income. And so it is a primary focus of ours through our audit processes to make sure that taxpayers are reporting correctly whether or not they're a resident. With that said, I'll open it up for questions. I do have one of our attorneys, Margaret Reisdorf, here to help address any questions that I might not be able to answer. Thank you, Madam Chair.
Thank you very much, Mr. Getchell. I appreciate that. Senator Howe has a question here.
Thank you.
Let me go ahead and close the PowerPoint screen so that everybody's tiles can come up and I can see the hands more easily. Thank you very much, Mr. Getchell. Senator Howe.
Mr. Getchell, is Is there a cross check, or if someone files with the federal government, with the IRS, and files that they are residents in 2 different states, does that come back? Is there something somewhere that you get notified that somebody tries to be residents of 2 states, or could that be possible if they lived in 2 different states at that time during that taxable year?
Mr.
Madam
Getchell.
Chair, Madam Chair, Senator. So I'm unable to speak to that question as it's part of our audit criteria, and our audit criteria is confidential. But I do appreciate that question. But there are many factors that we look into in terms of our audit criteria to determine whether or not we want to open up a lead and look into a taxpayer situation further.
Thank you, Mr. Getchell. Mr. Getchell, I would suppose that sometimes folks don't realize, but the enhanced ID has a chip in it. So does, I think, a passport card. And I would say the ability to find out where you are at any given time is probably through government sources. And if you've been kidnapped, that's good news. So those situations. I have a couple questions for you. So when you're dealing with tax residency, it's anywhere in the state of Minnesota, correct? Mr. Getchell?
Madam Chair, that is correct.
Right. Okay. But you do have to have a specific place. The other question I have for you that I think folks might be thinking here, well, when you say maintain abode, what is an abode? Because there are people who might have a cabin or might have a condo here or but that they have residency in a different state. So how do you determine that if, say, they have a cabin, or I don't know what abode means? If you could give more info on that.
Madam Chair, an abode really meaning a physical presence within Minnesota. And so, for instance, with your example, if a person does have a cabin within Minnesota, but they're physically present within Minnesota, and they meet that 183-day rule, they could be considered a resident of Minnesota for tax purposes.
Okay, so Mr. Getchell, what you're saying is 183 days, and you have a place in Minnesota, those 2 together, but the main thing is 183 days.
Correct. Those 2 together would match that statutory residency test. Would qualify as a resident under the statutory residency test. So
if they do not, Mr. Getchell, if they do not have an quote abode, whatever, a place,
yeah,
but they're here 183 days, Mr. Getchell, does that make them a resident?
Madam Chair, that does not make them a resident. They need to meet both of those conditions.
Both of those. Okay, thank you. In regards to residency. So Mr. Getchell, you make that determination using the same statute 200.031 that we've been discussing right now. Determination of residence in Minnesota statute 200.031.
I didn't, Madam Chair, I do not have that in front of me right now.
Okay.
But I most definitely could refer to Margaret Reisdorf right now if you'd like to.
Okay. Well, there are some factors that are involved here, but not necessarily. So, Ms. Stengel, are the documents of these statutes that we've referenced, like 200.031, is that on the committee website for this committee hearing? So Mr. Getchell could go look at it if he chose to do so. Ms. Stengel?
Madam Chair, I'm not sure if they are available. I think Mr. Bjorn probably posted them, but I haven't looked. And if they're not, we can certainly get a copy over to whoever needs them.
Okay, Mr. Bjorn?
Yeah, I can make sure those are posted, Madam Chair.
Okay, thank you. All right, thank you very much, Mr. Getchell. I find that was particularly helpful, and we would appreciate your time and consideration. I think I have other questions, but they're not. Our affidavit of candidacy is the primary thing right now, but I was interested in these, the fact that residency was actually including things like social, I'm not quite sure where I read, I think it was on the screen, family and community connections and social activities. So I thought that was interesting. So thank you very much for being here. But as far as what we're talking about today, I'll let you go. And thank you very much for your time.
Thank you, Madam Chair. I appreciate it. I did just want a quick follow up that for residency, it is that statute that you referenced that we do follow as well for residency. So thank you for your time today.
Thank you very much, Mr. Getchell. With that, we're next going to go for another piece of the residency issue that touches candidates, and that is from Mr. Sigurdson with the Campaign Finance Board. Welcome, Mr. Sigurdson. Appreciate your taking the time to be here today. And Mr. Sigurdson, when you do for the audio record, you know the usual name and title and so on. But then if you would proceed to just tell us about the filing for office with the Campaign Finance Board and residency, any information you can give us would be very helpful. Mr. Sigurdson.
Thank you, Madam Chair. Good morning, committee members. My information, again, is going to be focusing on what you need to file with the board when you register your principal campaign committee or campaign committee for candidate. There is slightly different variations with the information provided by a political party unit or a political committee or fund. So I'm just going to focus on the candidates committee since it's most relevant to you. The registration of a committee for a state level office is required by our office within 700. Once a threshold is reached of either collecting or spending $750 within the calendar year to influence your nomination or election to a state level office. There is a slightly abbreviated schedule for filing if it happens to occur during the filing period for a periodic report or during the 24-hour reporting period for large contributions, but basically you have 14 days to file. Accuracy is very much required on our filing to, I believe it was Senator Carlson had a question earlier during this hearing about whether or not there's a penalty or there's the potential for a penalty for filing false information. You do certify, either the candidate or the treasurer certifies that the information on the filing is correct. And if there is a knowing violation where information that they know to be incorrect is provided, that can be subject to up to a $3,000 penalty by the Campaign Finance Board, and it can also be referred to the appropriate county attorney as well. The information provided at point of registration is the office that you're going to be running for, the district that you're going to be running for, assuming it's a legislative office, the political party that you're going to be running for if you're going to be running as an independent. And then you break down your committee information, the committee's name, the address, overall address, and website if it exists for your committee, the candidate's name and address and phone number and email address, the treasurer's, same information for your treasurer, address, phone number, email address, and then for the chair of the committee, that same information. All information submitted to the board on that form is public information and is available on our website. But it should be emphasized that the statute does not require, and in fact, our administrative rule specifically provides that the information on the registration form does not have to be your personal information. In other words, you don't have to provide your home address, you don't have to provide your home phone number or email. You could provide one that you set up specifically for the committee. You could provide a PO box, and the administrative rule also provides that you could provide as a mailing address a business address. So even back, going back now decades, there was an acknowledgement that there might be security concerns, and that in terms of providing information to the board, we're not looking at how to put people onto the ballot or verifying that people are qualified to be placed on the ballot. We're looking for information so that the public can contact the committee and so that we can contact the committee for additional registration or reporting requirements as applied by Chapter 10A. You're also required to provide bank account information, although that does not include the specific account number of your committee. And the information must be kept current. It has to be amended within 10 days if there's a change to either an officer or some other filing information that you provide to us. This was supplemented at the last legislative session to provide an option, and I want to emphasize an option for all campaign committees and indeed party units and political committees as well, to provide personal contact information that is private and that will not be provided on the board's website and will not be used, private information not available to anyone other than the board for the administration of Chapter 10A. That includes an alternate mailing address, an alternate phone number, an alternate email address. Now, why does the board want that? Well, the idea would be that in many cases, the board believes, especially frankly dealing with volunteer treasurers, that many of the reporting requirements can become overwhelming and they simply forget about them. We're not trying to collect late filing fees. We're not trying to have candidates miss key filing periods, for example, for the affidavit of contributions. If that's not filed in a timely manner, you're no longer eligible for a public subsidy payment. So in many cases, it's imperative that we be able to reach the candidate or the treasurer within a limited period of time. And frankly, in many cases, the emails and phone numbers and even mailing addresses that were provided on the registration form, while accurate, are not necessarily checked on a periodic basis. And if you have a PO box for your campaign, that's certainly legitimate to provide that on the registration form. But unfortunately, we found that in some cases, PO boxes are checked once every couple of weeks, which doesn't really help us if we're trying to get an immediate response. So again, it's optional, but you have you should have received by now a form from the board saying that if you want to provide this information, you can. You'll keep it in a separate database that's not a part of the production database. It's kept in a lock cabinet. It's again not public information, but we'll use that if we get up to a filing deadline and we still don't have a report from your committee or some other key document, so we can use that to reach out to you. The other issue, which I think was touched on here briefly, and I'm just going to mention what the board's going to do. We were all aware, of course, of redistricting, which means that of the 670 or so candidates that are currently filed with us, probably 669 are going to need to change the legislative district number that they're registered for. We're going to be proactive on that. Once the final district numbers are available to us, we'll send out a mailing to the treasurer and candidate saying, please examine how redistricting affected you. If you need to amend your registration, please use the enclosed form. And we'll quickly make that hopefully as painless as possible for the committee to update that information. There is again a time deadline there because we need to have that information as we get ready to make public subsidy payments. And if we're not clear on what legislative district the candidate is in, or if there's some difference between what our registration says and what the affidavit of candidacy says that's filed and eventually provided to us by the Secretary of State or the filing officers, then obviously that has a problem. And so we'll be working with committees to make sure that their registration is up to date and as accurate as possible. The last part of this, and it's not exactly, perhaps doesn't always come to mind, but recall as a candidate, as a public official, you also have to file an economic interest statement. That again has information, but it's not required that you ever provide your personal mailing address on an economic interest statement. You do have to provide a business contact or some other way for us to get hold of you, but the instructions are clear that a private mailing address is not required and frankly is discouraged if we're talking about judges. So it is again an optional piece, but I just wanted to bring up the economic interest statement as another form filed with us that has information on the residence of a candidate. That's the area that I think applies that you seem to be, that the committee is considering today. Obviously, I'm open for any questions that you may have.
Thank you very much, Mr. Sigurdson, and members, you're welcome to ask questions. So Mr. Sigurdson, I think as we've gotten a general sense, so you have residency that is the Department of Revenue. You have residency from filing officers, whether they're Secretary of State, county, city, or township, all right? But we all use that same chapter of residency. But for the Campaign Finance Board, I get the sense, and I just want to check this with you, it's about the campaign committee filing as compared to an affidavit of candidacy, which is specifically about the candidate. But when they're filing with your office, with the Campaign Finance Board, it's about the committee making a filing. Could you clarify kind of the the perspective of that. And have I stated it correctly, or is there some other nuance that you'd like to add? Mr. Sigurdson.
Madam Chair, I think that's an accurate statement, because remember, we're registering not you as an individual candidate for placement on the ballot, which is the job that you're talking about, the filing officers. You're registering your campaign committee, which will be the instrument in which you provide information to the board, or the candidate provides information to the board on the money collected and the expenditures made. Now, on the registration form, the candidate clearly has to be identified, and contact information has to be provided, but it's not, the board has that separation. We're looking at campaign finance information. We're not looking at residency information to determine whether they should be placed on the ballot for a particular district. So the information that we're trying to get is to make sure it's accurate for the district, so that frankly, so our website makes sense. So you can say, show me all the candidates filed for District 63B or whatever it may be. But we're looking at being able to provide the public information on the committees registered for 63B. We're not really drilling down to the candidate's personal address.
Thank you, Mr. Sigurdson. I think you've added some good clarity to this. Senator Carlson, I think you might have had some questions about this area that might be a good opportunity for you to broach them at this time when you're unmuted.
Actually, Madam Chair, I had a question previously. So yeah, we're not on that subject anymore. So I'll let that ride, and I'll ask separately. So thank you for calling on me. I didn't get my
sure. Oh, no, you didn't have your hand up. I just knew this was something. And one of the reasons why we had Mr. Sigurdson on is because of when I talked to you about having this hearing ahead of time, you brought up this question. And I think we've probably clarified your question a little bit better through this whole hearing, but I just wanted to give you an opportunity if there was something additional that you wanted to bring up.
Oh, thank you, Madam Chair. Actually, I was looking at something here just on the side, and that was the exact timing when a person has to declare their their residency if they do not meet the criteria for filing a committee. That, because there have been some candidates for office who do not have to spend much money, and I guess I would say that they're judges, for instance. And so if they have not spent and I believe we're talking $750 or collected $750, that they don't need to file a committee. And so they don't need to divulge their address until they probably file for office. And then I heard you say something about that some candidates are exempt from having to declare their location. Does that refer to judges?
Mr. Sigurdson.
Madam Chair, Senator Carlson, I think I think there may have been more than one question there. The first question was the judicial campaigns, and you're right. If you look at our website, there's probably, I don't know, 8, maybe 10 judicial campaigns, and of course there are hundreds of judicial candidates, even up every state election year. And the fact is if you're unopposed, why would you bother collecting money, doing advertising if you're unopposed? And so the great majority of judicial candidates never form a committee with us. The other issue is that, and by the way, this is maybe more of a detail than you want to know, but there is sometimes a question of as to why do we get a copy of the affidavit of candidacy. I think that was referenced by Mr. Trippett for Ramsey County, is that we get a copy of that. And the reason is that you may recall that there's a timeline for filing an economic interest statement of 14 days of when you file for office. And often we're dealing with candidates who have never heard of that requirement. And so we want to get a copy of that so that we can reach out and contact them and remind them that, this is a requirement. We provide a packet to the filing officers, but unfortunately our experience is that packets sometimes go on a desk and aren't opened. So we again try to reach out to those individuals to let them know that. But there is, you're certainly correct, most judicial candidates never form a committee simply because they're unopposed for office.
Thank you, Mr. Sigurdson. Thank you, Senator Carlson.
Madam Chair, I have another question that is
Sure,
different. Yeah.
Go ahead, Mr. Carlson. Senator Carlson.
We have had a candidate who has not been a resident of the United States. Evidently is a citizen, but this person, I think I can probably say so everybody remembers him. Jack Shepard is his name, and he lives in Italy, and he actually has a, I think he's under arrest order, and he has continued to file for office and has continued to attract votes. And I'm wondering if there's some kind of violation that's happening here, or if there's a filter that can make sure that someone who has not lived in the U.S., I don't know if he's actually met the requirements for continuing his citizenship, but he seems to be a perennial candidate. And I'm wondering what is the situation there? And actually, how does he get on the ballot? Is he using the petition?
Thank you, Senator Carlson. Mr. Sigurdson, do you want to try that one?
Madam Chair, Senator Carlson.
Recording stopped.
I'm afraid that I'm going to have to show
Recording
some
in
ignorance
progress.
here. I'm not sure the process that he's using for getting on to the ballot. I think, as I vaguely recall, going back over 20 years when I used to work for the Secretary of State's office, there is the ability to use your, I think it was pointed out, you don't actually have to live within the state to file for US Congress. So it could be that he's using that approach to file for office, but I'm sorry, I don't have any specific details on that.
Okay, thank you.
Well, Senator Carlson, I can add a little bit to that. Actually, there was a court case in regards to Mr. Shepard, and the court said, notwithstanding a warrant for his arrest, should he put foot in the U.S., notwithstanding the fact that he lives in another country, he was still able to be on the ballot.
Okay.
Interesting, isn't it? Senator Howe, you have a question?
Thank you, Madam Chair. And Mr. Sigurdson, I find it odd that you have to file within 14 days of forming a committee, but how do they, so it's not when they, or is it when they file? Because I guess my question is, how do they know they're not going to spend more than $750 when they open up, when they start? I mean, I would have to say that some people may not plan to spend more than $750, but what happens if they do and they're past that 14 days?
Mr. Sigurdson.
Madam Chair, Senator Howe, the 14-day threshold, or the 14 days starts at the threshold. So regardless of what they expected to spend, once they find out that, oh, I went over $750, now I have 14 days to file, even if I never intended to. I will say that many committees file preemptively. I mean, it's not like you can't file until you reach $750 or until you've collected $750. Many candidates will file with the Secretary of State, walk over to our office and file their committee under, with optimistic hope, I guess, that their committee will be successful. So the threshold starts, or the 14 days, starts ticking at the $750 threshold, but you could certainly file preemptively if you wished.
Thank you, Mr. Sigurdson. Senator Howe.
Thank you, Madam Chair. So if they never report that they did any of this, how would you ever follow up and check on them to see if they actually did collect or spend more than $750 if they never file?
Good question. Mr. Sigurdson.
Madam Chair, Senator Howe, there's two things here. Well, one new part of statute, which I haven't talked about before, but I'm going to throw out to you. There is also a provision that says that if you're a candidate and you don't collect money from anybody else, you accept no contributions from individuals, party units, PACs, period, you're just going to be self-funded, then you don't have to file a committee. If you're self-funded, there's no requirement to form a register or form a campaign committee with the board. However, that's another part where we look at the affidavit of candidacy, because we're still going to know you're on the ballot. You still have a filing requirement, even if there's no committee. We send out a letter to those individuals saying that, you know what, you don't have a campaign committee, therefore you're stating that you are receiving, or you're not receiving any funds, you are only using your own money. but you still need to file this report saying what your expenditures were for your campaign. And so there is a reach out to those individuals, even if they don't form a committee. The second part of your question as to, well, yeah, but how do you know that? Chapter 10A, frankly, has always relied on the review of the candidates' opponents. I mean, we are a staff of 8 and there's 201 legislative districts. The board has never been able to say what's going on the ground on 201 legislative districts. Our role here is to be available for complaints. If you see a candidate with radio ads and yet they haven't formed a committee, that's the basis for a complaint, saying it certainly appears that they haven't met their registration and reporting requirement, and the board will then take action and investigate that. But in terms of being able to know what's going on the ground in 201 legislative districts, we really don't. And that's why our role is to make sure that the information that is filed by us and that is organized by legislative district allows people to look at and say, how come there's no information for this candidate? And I will say that it's not unusual during an election cycle that we get complaints about candidates who should be filing, registering a committee at the very least, or filing committee reports or expenditure reports if it's a self-funded campaign.
Thank you very much, Mr. Sigurdson. That was a really good, informative answer. Senator Osmick has a question. Senator Osmick.
Thank you, Madam Chair. Mr. Sigurdson, in general terms, can you explain to me what the purposes of campaign financing spending limits? I'm sort of curious on what your read is on that.
Mr. Sigurdson.
Madam Chair, Senator Osmick. Well, the spending limits, remember, only apply to a candidate who agrees to the public subsidy agreement. So a candidate who doesn't agree to that has no spending limits for their campaign. So it's basically, it's a contract. The state is saying that in exchange for the ability to issue political contribution refund receipts to your contributors and to receive, some sort of payment, assuming that you win the primary, as a direct public subsidy payment. In exchange for that, the state believes it's valuable to limit the overall expenditures made by the campaign committees. That's the trade-off, and so that's the rationale, I guess, for having that spending limit. Is it's modifying candidates' behavior in exchange for those two programs.
Thank you, Mr. Sigurdson. Senator Osmick.
No, I think Mr. Sigurdson probably knows where I'm going. The penalties for individuals who decide to not honor the campaign spending limits are virtually none. I mean, your opponent, if they sign and agree to them, they're bound by them from to the end of the campaign. But in reality, the individual who decides to spend out of their checkbook, or as some people may even say, go into their golden Rolodex and have a lot of money flow into their campaign, there's really no penalty. There's really no consequences for somebody to spend $1 million on a state Senate seat. And earlier, Madam Chair, last year, or this last legislative session, I had some legislation to sort of add some additional teeth to that law. I'm not sure if Mr. Sigurdson has any opinion. I know I contacted him regarding this, but he probably wants to stay out of this mess. But Madam Chair, that's the reason why that I had that legislation, is because there needs to be something more teeth involved when you're going to try and spend $1 million. So that's all I had. Thank you, Madam Chair.
Thank you, Senator Osmick. I appreciate that. And thank you, Mr. Sigurdson, for being here. We do want to be sure that we can stay a little bit on topic, which has to do more with residency right now. Though, Mr. Sigurdson, you're obviously an informative person, and appreciate the fact that I let the committee go a little bit to have questions. One other thing I want to clarify on the record here, though. So, Mr. Sigurdson, this is in regards to economic interest statement. And again, there's a filing deadline for that. Is that triggered by when you file your affidavit of candidacy, or is it after the end of filing? Can you just clarify that, since we've touched on it and folks might have gotten a little bit mixed up with all these deadlines being talked about? So if you could just clarify the requirements for the economic interest statement, when it's triggered and how many days.
Certainly, Madam Chair. It's 14 days of when you actually file for office. It isn't from the end of the filing period. It's from when the actual affidavit is filed. So that's why we need to, again, get a copy of the affidavit of candidacy as soon as possible, is because we're not going to know about when that 14-day period started without that document. And although we obviously are looking at the Secretary of State's website as well, but it allows us to reach out to those people and tell us that this is really a short period of time, 2 weeks, to get this document to us. So again, I'm directly to your question, it's 14 days from when they file.
Thank you, Mr. Sigurdsson. I've seen that as an issue before with a lot of people. They think it's 14 days from the end of the filing period, which would be quite logical as well. And then this economic interest statement is also required. So there's a lot of requirements in regards to that, but I think a lot of people miss it because they think it's from the end of the filing period. It's not. It's when you file your affidavit of candidacy, easily missed. And it might be something in a future legislation. Senator Carlson, as the Democrat lead on this committee, this might be something that a change to 14 days for economic interest statement from the end of the filing period, which would then make it the same for everybody, no matter when they filed. It might be easier to follow up with. I'll check in with you, see what you think. Okay, all right, good. All right, members, with that, I don't see any other questions in regards to that. I want to thank everybody, the Secretary of State's office, Ramsey County office, the Department of Revenue, our own General Counsel, Ms. Stengel, Mr. Sigurdsson from the Campaign Finance Board. We appreciate all of you taking your time here today and give us information, and even your pet cat, Senator Carlson, is cleaning your glasses. And so we thank you all for taking the time to be here today. And with that, our committee is adjourned. Thank you. Ms. Lane, are you going to lead off here?
Senator Kiffmeyer, I am happy to do so, but I'm also happy to let Lorna Smith do this.
Whichever
and
one.
provide
Just
the quick little overview. We've got a couple slides to share, so I'll put those up on the screen, and then both Ms. Smith and I are available for questions as members kind of jump back on. So I will go ahead and turn my camera off and put my screen on with the quick
for the
slides.
PowerPoint. Okay.
Yep.
All right. Yeah. Good. You've got an overview of all this, so that's great. Thank you. So Ms. Smith, you're going to go ahead and then you're going to do a share screen. Thank you.
Yes, thank you. Well, thank you, Chair Kiffmeyer. My name is Lorna Smith. I'm the Director of Employee Insurance at MMB. If we can go to slide 2. We're going to give some quick background here for this. CGIP is the State Employee Group Insurance Program. We provide employees, retirees, and their eligible family members with insurance benefits. This includes all 3 branches of state government, Minnesota State, and the quasi-state agencies specified in statute. The medical program includes a pharmacy benefit manager, or PBM, who administers the prescription drug benefits for all members. Legislation passed in June of 21 requires CGIP to select its next PBM through a reverse auction and then conduct ongoing invoice reviews and annual market checks. This requires first contracting with the platform vendor and then selecting the PBM itself. If we could go to slide 3. We are almost at the end of the platform vendor selection process. We issued the RFP in early July and extended the due date to August 23rd. We made the extension to allow potential responders more time to prepare their submissions. When the submission phase concluded, we'd received 2. MMB made an initial scoring of the vendor submissions. Then, with an interview team comprised of union representatives and CGIP staff, we interviewed the responders and made the final selection. After the interviews were concluded, we asked the responders for a best and final offer. That second round submission and the work of the selection committee's choice resulted in a clear selection. Unfortunately, under MS 13.591, only the names of responders are public information till the selection process is over. We are currently in contract negotiations with the selected vendor. We expect those negotiations to be concluded later this month, and then we'll announce the winner. If we can move to slide 4, please. Once we have a platform vendor under contract, we'll then start working on selecting the PBM for the 5-year period beginning January 1 of 2023. The selection process will begin right away, as I said, and we are on schedule to issue the RFP in January of 22. This is important because the whole RFP and contracting process will take approximately 6 months, and then the PBMs typically require 6 months to implement their program, and that will get us to January 1st of 23 when the new contract begins. We believe the process is moving along as smoothly as these projects ever do, and that will conclude on time with an appropriate platform vendor and PBM for the state. And with that, I'm ready for any questions you might have. Senator, I think you're muted.
Thank you very much, Ms. Smith. I appreciate that. Ms. Lane, did you want to add anything to that before I go to questions?
No, thank you, Senator.
All right. So I appreciate the update and things here. I think I do have a few questions. One of them has to do with the reverse auction to be performed at no cost to the state. And so how are you going to structure the costs associated with securing and paying for the technology vendor?
Well, Senator Kiffmeyer, I think the statute had, well, first of all, there is no way that the state isn't going to pay for the reverse auction. We can require the PBM to pay for it, However, they will simply increase their cost to us. So there is a cost. Currently, we are planning on paying the reverse auction costs upfront. That is the most cost-effective and most transparent route.
Okay. Well, it says that in the state contracting law requires that if the state, meaning M&B in your case, pays for the tech vendor upfront, the RFP process to procure that vendor must weigh at least 30% of the RFP point scoring on cost. All right, so you're doing that as well. Is that correct, Ms. Smith?
Senator Kiffmeyer, yes, that is correct.
Okay. All right, we do want to know about that, but I was just kind of, that's triggering that 30% scoring position. That's actually putting quite a bit of emphasis on that. I think the intention when we talked about this before was to not do it that way, but I was just kind of interested in the fact that it was. Can you elaborate a little bit more? Why would you do it that way rather than in having the vendor included?
Well, Senator Kiffmeyer, you know, we can have the vendor, the PBM vendor that we select, pay for that cost. But it doesn't reduce the cost. I mean, the cost is still the cost and someone's going to pay for it. If, like I said before, if we have the PBM pay for it, they're simply going to increase their costs to us. I believe that by paying those costs up front, it's the most transparent and we all have a clear understanding of what the process is costing us. And, you know, the other thing I will point out is that we're going to be signing a contract with the platform vendor later this month. That platform vendor is going to begin work right after that. So they're going to work from now all the way up until we have a contract with the PBM, which will be sometime around June of 22. That would be a long time to go without being paid. That's a lot of work they will have done. And I can't speak for all vendors, but I would assume that at least some of them would increase their cost if they had to wait that long to be paid. I don't know that they all will. I had one tell me that they wouldn't increase their cost, but.
Okay.
You know.
All right. Thank you very much, Ms. Smith. I especially appreciate the elaborating on the reasons for doing it that way. I think one of the other things that we did a lot of work on was the minimum standards, 6-hour turnaround time for the reverse auction per round results. There were several criteria, minimum standards. Could you tell me in the implementation in regards to those, I think some of the questions that came about were they asked about in the tech platform RFP or in subsequent questions? So that was quite a big issue of discussion, those minimum standards. And so could you address that area and how you accomplish that in accordance with the statute?
Thank you, Senator Kiffmeyer. Yes. One of the things that we did when we wrote the RFP is we included a copy of the statute. And one of the questions, excuse me, I have a cat. One of the questions was for the vendor, the responder, to tell us in detail which of the provisions in the contract, if any, or I'm sorry, in the statute that they were unable to comply with. Mm-hmm. So they were expected to go through and that was it. I unfortunately can't go into more detail with what the responders said, but I will say that some of those timelines did prevent others from responding because they couldn't meet all the provisions of the statute.
Okay. All right. So that would make a difference in regards to that. Okay.
Yep.
Thank you very much. I appreciate that. So how are you thinking right now? How many respondents? I know we're not going to ask about any content. We understand that. How many have you received to date?
The responders were due. Thank you. Sorry. Thank you, Senator Kiffmeyer. The responses were due in August, and we received 2. And under the statute, we can tell you the names of the responders, and that was Truveris and SkySail RX.
Okay, so we did get 2 of them. Okay, and because of sending in the statute and compliance with that, you can get a ton of vendors sometimes, but if they can't comply with the statute, it's kind of a waste of their time and a waste of our time to go through it. So it's good that we do have those 2. That's important. And so you've sent to us today the timeline and so on, and this goes all the way through to providing services. So I really appreciate that. It's nice to have a specific date in here right now in regards to the process of the selecting the vendor. So you're in a very close, the best and final offers that we have on September 28th, October 1st, and so on. So do you have a vendor of those 2 vendors? Do you have that selected yet?
Yes, we have selected the vendor, and we are in contract negotiations with that vendor.
Okay, so which one of those 2 you're not able to say?
Yes, Senator Kiffmeyer, we are not able to. We're not able to announce that yet, but
okay.
we will.
Yes.
Within
yes.
a few weeks.
Sure, I understand that. I just wanted to clarify. Sometimes I ask those questions also so that the public knows, not just us who are dealing with all of this. And the other thing is the joint labor management, the JLM folks were engaged and involved. That was a really big issue when we passed this legislation. How has that worked out, and how have you found that process to be going so far? Their engagement, have they been well engaged? Just address that in general. Ms. Smith.
Thank you, Senator Kiffmeyer. Yes, the statute, well, there's a couple answers in here. First of all, the statute required them to be involved in the selection of the PBM and not the platform. They expressed a strong desire to be involved in the platform vendor selection. And so we did let them come in and partake in that. They were part of the interview process, and we had a voice vote as to who we wanted. And I will tell you, trying to figure out if I can, well, I'll just say
it's okay,
there was
just
no
leave it.
controversy. I'll put it that way.
Okay.
I think that they are very happy with the outcome. I'll leave it at that. We have a meeting with the steering committee of the JLM later this month, and one of the agenda items is discussion of the PBM platform vendor selection and where we're at. I'm hoping that by that time the contract will have been signed and we can have a fuller conversation. And we'll be selecting their members that they would like to be on the PBM for the actual PBM selection. I will tell you that our policy is that whenever we're selecting a vendor that provides direct support, so the PBM, the medical administrators, the dental administrators, our EAP program, we always have union representation on those selection committees. The unions have input from employees that we don't have, and that input is invaluable and absolutely needed. So we do regularly, and we do meet with the JLM every other month during the periods we're not negotiating contracts, and we discuss various aspects of the program and different things we're doing. So we work closely with them. We typically don't have the union participate when we're selecting vendors that will provide us with consultation services. That was the one difference and why we originally weren't having them involved with the platform vendor selection, but because, as I said, they felt strongly, we brought them in.
Thank you. I think actually the JLM in statute actually had I have the statute in front of me here, and I think that that was a very important consideration for us as well. So I think they do provide a good value in their involvement and also in the criteria. So I really appreciate that. So members, in regards to this reverse auction, the goal is for this, for some of you who maybe weren't deeply in the whole process, the reverse auction as experienced in the state of New Jersey, and then also in other states as well, has reduced costs of prescription drugs, and also making sure that the pharmacy benefit managers are in compliance with their own contracts, with their own language, with their own statements. So I think that is an important consideration for us. This is a goal here, is to have a tremendous value for our state government employees, that they have the best value, the best service in regards to their pharmacy needs. And that was the point. So this is a new way of going at it, and of effort for that based upon other state, in particular New Jersey, having success with this. And again, I appreciate MMB, your work, you, Ms. Smith, and you, Ms. Lane. We appreciate that very much. I know there's a lot of technical things here, and at some time in the future, the committee will probably ask you in again to give an update once you are through all of these contracting things, and there's a little bit more that we can hear about. But in the meantime, I appreciate very much your being here today to have the update, and give my regards to Commissioner Showalter. So members, if there are no other questions, this actually does now complete the agenda that we have for today. And I appreciate all of you and your time and attention for this, and trust it has been informative and helpful to you. And with that, members, seeing no further discussion or questions, I'll declare this meeting is adjourned. Thank you.
Recording stopped.